Hello everyone, this is Sachin Sawant, your UK immigration lawyer. Today I'm going to answer the questions that have been asked on the channel through the comments. If anyone is coming live, you can ask any questions. I'll try to answer them as much as possible. So the first question that I have is from Vaghela Namrata. Is it confirmed that spouse visa requirements going to change from 18,000 to 29,000? So yes, to the best of our knowledge, the immigration rules have not been published yet, but the current government has declared that they are going to make these changes. So immigration rules have not been drafted. We have not seen that yet, but it is in the news and also in the government's fact sheet, they have given the details that it is going to change from 18,600 to 29,000. So yes, to the best of our knowledge, yes, it is going to change, but we never know if the government decides to not to go ahead with the changes to the spouse visa financial requirement, but we have to just wait and watch. But most probably, anytime the government declares some of these things, they do the changes. They may change it back again, they may do further changes. But from what we know from experience, usually if they say they will do some changes, that's what I think. But yeah, we have to wait and see when the immigration rules come into play, when they draft and publish the immigration rules, which is not yet done. So the next question is from Munawar. We were on the graduate route visa and my wife switched to a student visa in December 23 intake. Then I applied for a dependent visa on 1st of January. So the new rules will not affect my visa. Explain new rules for existing dependent visas. Okay, so the question is about you. We were on a graduate visa, switch. Okay, so the couple was on a graduate route visa, husband and wife. So the main applicant and a dependent on the graduate route. I think you may be a dependent also on the student. So you switch to a student visa. So from graduate, your wife switched. So a dependent switched to a student visa, and you became in December 2023 intake, and then you applied for a dependent. So basically, so you're asking about switching from graduate route visa to becoming a to on a to changing to a PBS dependent visa as a dependent of a student. Uh, so firstly, is it possible you can become students dependent? Yes, you can become the students dependent only if they are doing that PhD qualification, whatever the new rules have come into place. So that would affect yours because I think the course start date you said that was from December intake in December. So I think if the course start date is in January, then the changes would affect. And the dependent, that is, you can only become a dependent on the student, that is your wife, if she is doing that PhD or thesis. There is another video on that, so I've explained everything. So it is kind of a PhD or a thesis related course. So only then, not on any other type of course. So the new rules will not affect my visa. The new rules will affect your visa. The new rules of dependent not allowed on for students other than the PhD students would affect you if the course start date of your wife is after 1st of January 2024. That's how I understand it. And you are asking, can you also explain the new rules for existing dependent visas? Existing dependents, yeah, it doesn't matter whether you're an existing dependent main applicant. The way your application will be decided is as per the new rules. If the course start date of your wife's visa is after 1st January 2024, then the PhD qualification kicks into play and all of those things come into play, which were declared on 17 July 2023. Yeah. So, yeah, anyone joining live, you can ask your questions. I will try to answer them. And I'm taking the questions from the channel now. So, next question from the user. I missed your session yesterday. Okay. I came on a care home visa, but the employer is not giving me the job as promised. Can I apply for a skilled worker visa to work as a shopkeeper under another sponsorship license from the UK? So, yes, if you want, so this is common with these care homes and all, whatever frauds have happened. So I made several videos on not buying those skilled worker visas and all of that. So if you are given a care home visa and then you're not getting hours, it's a very common occurrence. I hear this almost every other day. So yes, you can. The question is, can you switch to another sponsor, a skilled worker visa as a shopkeeper under another sponsorship license? Yes, you can move to another employer under other job code also. There is nothing stopping you from doing that. You can change employers, you can change job codes if you do qualify for the new job and all. So yes, it is possible to switch to another sponsor and work as a shopkeeper. In your case, it is possible. Uh, Dear sir, what if BRP card is getting expired next month? That will be 10 years. Changes to the long residence, 10 years long residence indefinite to remain. Okay, in the question you have asked is to the comment is on the changes to 10-year long residence ILR. Dear sir, what if BRP card is expired, getting expired next month? That will be 10 years. Sorry, I don't understand your question, but I'll try to interpret it in my way. Uh, you can clarify and put another comment later on if I have not interpreted this correctly. What if so your BRP card is expiring next month? So we are in January. Let's say your BRP is expiring in February. That will be 10 years. So in February you will be completing 10 years. That's what I'm assuming. Maybe you are asking a question, you are short of 1 month before completing the 10 years and your BRP is expiring 1 month before the 10 years completion. It is possible to apply and delay the applications and all of that. So maybe speak to an immigration lawyer if that is your question, that your BRP is expiring before and after 1 month of that you may be completing 10 years and you're trying to apply on the 10-year long residence rule. Then it may be possible to apply early and delay some things here and there, but speak to an immigration lawyer for that. Yeah. Next question, I had it for the chef jobs, they need to be paid the usual annual going rate of 17,100. So this is a common confusion. Yeah, I've spoken to many people on this during consultations. Also, people are confused. I've seen that. So I'll just take this chef job example. The question that you asked, I had it for chef jobs. They need to be paid the usual ongoing rate. If you are trying to get a skilled worker visa, and if your job code, for example, chef job code, the going rate in the UK is 17,100 annually for a 37.5 hours week. That's what you're looking at. But if you want to be sponsored as a skilled worker, the minimum of 26,200 will have to be paid. Because to the best of my knowledge, chef is not in the shortage occupation, etc. So there is no discounting. So people do get this wrong. They always go on that list of jobs and the minimum salaries to be paid. For example, in your case, chef has to be paid 17,100. But in order to be sponsored for a skilled worker, 26,200 will have to be paid as of today. So that is the current rule, which is going to be changing to 38,700 as proposed by the government around April sometime. So you cannot be paid 17,100, you have to be paid 26,200 for minimum hours of 37.5 hours working week. Next question, dual partners. Okay, my partner has EU press. So this question is about EU settlement scheme. My partner has EU pre-settlement scheme. We date since 2019. Okay, married recently. Would I be eligible for family permit? So this is also a common question. Many applications are getting refused in this area where the relationship has not started before the end of the transition period, that is before 31st December 2020. If you are not married, you may be dating for however long, maybe 10 years. So in your case it is 2019, but that is not taken into account. If you have married now after 31st December 2020, then you cannot apply for the family permit under the EU settlement scheme. You cannot get any status under the EUSS. You have to apply for a normal spouse visa under the British immigration rules, where the normal requirements of English language, financial requirement, 18,600 currently, all of that comes into play. So you cannot apply, sorry, because you have got married after the end of the transition period. What are defined and undefined services? Okay, I'm already working for a company. They want to sponsor me currently. I am student. In a few months, I'll get clearance from school. company want to sponsor me, do they need to make an ad of a job interview, etc.? Yeah, so yeah, I will briefly answer this question. I try to answer within 1 minute. That is what these sessions are for. So you are working with a company, you are a student, and you will be completing your course of study after within a few months. So you are asking what are the steps that the employer has to take. They need to apply for a sponsor license. If they don't have one, they should get one. Do they need to make an ad of the job? They can to justify that it's a genuine employment, but it is not compulsory. Usually, yeah, it depends on the type of job and all. But if they do, it's helpful. They don't have to. The resident labor market test requirement has been taken out. Interviewing and all, yeah, job, placing an ad, interviewing, etc. They can do that if they want to, but as per the immigration rules, it is not required. They may do that just to justify to Home Office that they have looked for someone in the resident labor market also, but it is optional. They don't have to do it as per the rules. What are the benefits of being on the 10-year family route to settlement? Okay, so on this one, how can I know which route I am on? 5 year, 10 year? I don't know how to find this. So to find that, so the question is, this is also another common question I do get. You may just have the BRP card. I don't think the BRP card will state which route you are on to. Usually the route to settlement, 10-year route or 5-year route, is stated on the approval letter when your visa is approved. So if you want to know, go back and check that approval letter or email that came from Home Office. Or if you don't have that, then do a subject access request with Home Office. There should be other videos of how to do the subject access request. You can Google for SAR or EKVI subject access request to get your information. On our channel also there are other videos, and then that's how you can ask for the copy of the approval letter and then look at it, and it should clearly state which route you are onto, 10-year route or 5-year route. So that's the only way if you don't have a copy of that approval letter or approval email. Next question, if a student is unsuccessful to pass one subject, can he get PSW after pass it after degree time? So the question is about PSW visa. If you fail one subject and then you pass it, it depends when you pass it. So before they make a decision on your PSW application, you should have passed it, because the caseworker will check with your university, and at that point they have to confirm that the course is successfully completed. This is for PSW, not for skilled worker visa. So for PSW, yes, at least by that time you should have passed that course fully. Next question. I'm self-employed. Can I also use cash savings for my spouse visa to meet the requirements? Self-employed people cannot combine cash savings with the self-employment income. It's weird in the rules, but I understand that. I know they are trying to avoid double counting uh, of income, etc. But yeah, I think self-employment cannot be combined with cash savings. You can, let me think, you should be able to, but then check on the rules. I'm pretty sure it is not allowing. Hmm. Yeah, to the best of my knowledge, self-employment income cannot be combined with cash savings. Salary employment can be, self-employment cannot be. Yeah. Next question is, what are the requirements for unmarried partners of skilled worker visa holders? I see that the partner definition used to be marriage, like living together for 2 years. However, with the latest changes, living together for 2 years part has been omitted. Yeah, that is not right. I understand people are trying to interpret this. I had some other inquiry also on this. So this is about unmarried partners. Any unmarried partner who wants to apply for an unmarried partner visa. So what are the requirements? So unmarried partners of skilled workers. There is an appendix relationship. So there is some appendix relationship requirement has been added. Uh, Under that also it does require cohabitation. So what are the requirements for unmarried partners of skilled worker visa holders? That is your question. you would need last 2 years of cohabitation evidence. There is this just confusion, but the rules are the same that 2 years of cohabitation will be required. Whatever the interpretation of those changes you are making, I don't think that is correct. You would need the cohabitation evidence of living together for the last 2 years. Next question. Thank you for that. I know it's off topic, but I have a question about IELTS. As my fiance is in Philippines, does she book her English test? Does she book her English test? So your fiance is Brian Dawson. Your fiance is in the Philippines, and you're asking of booking the IELTS test. She can do the IELTS test in Philippines. There should be an IELTS center, and she can pass the center test over there itself. And if she is already in the UK on a tourist visit or something, she can also pass that in the UK. It doesn't matter where she passes, but it has to be at the approved center. It has to be a UKVI approved test. So she can pass it in Philippines as well. Next question. If we get ILR card, can we go to India? We stay there for 1 year, come back again to the UK for a month, again go to India just to keep the ILR active. What is the procedure? Yeah, so this is also this is called as abuse of settlement. So whenever you apply for indefinite leave to remain on whatever basis, you confirm your intention that you want to live in the UK, you want to settle in the UK, and that's how you apply for the ILR, indefinite leave to remain or settlement. And if you're trying to just keep the ILR, so this question is about if you get ILR and then leave the UK and then just come to the UK as a tourist or short periods to maintain that ILR. At some point, the immigration officer will observe this and they have a right to cancel this. In the past, it used to happen. I've not heard much in the current days, but they always have the discretion if they see that you have indefinite leave to remain in the UK, but you are not staying in the UK and you are just coming to the UK on the first instance. They may leave you on the second instance. They may give you a warning saying you should be living in the year. ILR is not just to visit as a tourist. At some point of time, they would definitely cancel it. Uh, they have a right to cancel that. If you are not settled, you just got the settlement and you are using it as a tourist just to come in and out, at some point that abuse will be stopped. Home office has not gone into, they are not actively searching for people, but as soon as they see a pattern of someone entering exiting and doing this regularly for some period of time, maybe 2 to 4 years, they will get to it. Definitely they will. They have the right to cancel that ILR. It's the same, it works the same way as green card. I think that's what I've heard about it. So, KP, your live question. I got my skilled worker visa 2 months back. I am planning to visit India in next few months for a month. If I can work from India remotely, will that 1 month be counted to be eligible for ILR? So, yeah, this is a common confusion that people have. When where you are working from, it doesn't matter to the home office. That's between you and the employer. The employer has to report hybrid working, whatever that is. So, those things are completely different. But when you are trying to count that period, you will be subject to, for the ILR, the way it is looked at is your presence in the UK. Doesn't matter whether you are working for your employer, you are on sick leave, whatever that is. For ILR, if you are outside the UK, you are outside the UK. So all those absences should be counted towards the 180 days limit in any 12-month cycle. So that's how you look at it. It doesn't matter whether you are working from there or not. If you are outside the UK, that is an absence from the UK. Very simple. Live guidance, we can card. Next question that I have here is, how can a dependent on a 10-year family route, and if I will qualify for a student loan for university if they haven't made 7 years in the country, please let. I am sorry, I am just an immigration lawyer. I cannot advise you on student finance or student loans. Yeah, so I am not qualified to advise. I don't know about it, whether you would qualify for the loans or not. Next question, can I set up? Okay, I want to open a small company in the UK. I'm from Pakistan. Yeah, if you want to open a business, small company, whatever that is, you have to speak to an immigration lawyer, take a proper advice on starting businesses and all, and take it from there. Next question, Mukesh. Live question. I want to marry my girlfriend who is a UK citizen. I'm currently in India, but her salary band is less than 29K, which is the new limit for spouse organizations. Yeah, the new limit has not yet been published. It will be coming into play around April sometime. So if you marry your girlfriend now, and if your girlfriend is already earning over 18,600, then after marriage you can submit the application. The date of application, so let's say if the rules are changing on 1st of April, I'm just taking an example here. The rules have not yet been drafted. Only a fact sheet has been made and details have been given to us. I've read the whole fact sheet on that. So if you apply on 31st of March latest, let's say the rules change on 1st April, for example, and you apply on 31st of March, you will still qualify under the 18,600 requirement. So if she is earning 18,600 annually, then I would say you do have time. We are already on 12th of Jan. Yeah, quickly you should arrange the wedding, get married, file the application before the rules change. So as of today, it is still 18,600. Okay, next question. No live question on the channel in the comments. Spring Sai Fili जो लिखे हैं यहाँ dependent को नहीं बुला सकते. I'm not sure what do you mean. Should not be called dependent on spring syllabus. Do you have high salary requirements? Sorry, I really don't understand your question, Arslan. I don't think it is in English. You asked, use some Hindi words. I'm not sure. Spring Sai Fili जो है वो कॉपी का salary requirements है. Sorry, maybe convert this in English and ask. It's very difficult for me to read Hindi in that English words. Yeah, maybe translate it in English and ask again under comments. Okay, next question. Hi Sachin, thanks for the information. I'm out of 180 days in recent year due to family circumstances. May I know what kind of evidence is that I need to submit to make ILR successful? Yeah, ILR due in 6 months. Yeah, so Shrikant, you have been outside the UK for more than 180 days in a 12-month cycle. I'm assuming you are on a skilled worker visa. You have not stated, but I think you are on a skilled worker visa. There's a reason you are concerned about that 180 days. There is no explanation you can give. It's quite a strict rule. If you are outside, you break the continuity of residence. You will have to keep on extending your skilled worker visa till that 180 days block goes out of your 5-year qualifying period for ILR. Giving evidence does not help. There is no discretion on the part of the caseworker for skilled worker ILR. So, next question. Okay, thank you, Mukesh. Kind of next question is my course end date on my CAS is 26 January. My employment starts in 27 January. Then I apply for skills worker visa. The home office asking for evidence of course completion. Very interesting. Okay, so the question is the individual's completion date is 27 January. The start date on the certificate of sponsorship, he has made a skilled worker application. The start date on the course has been declared by the employer as 27 January, which is as per the rules, I think. So if your start date of work is after your course completion, then Home Office should grant you a visa. I'm not sure why the Home Office, and your question is the Home Office is asking for evidence of course completion. At this point, you cannot give course completion evidence. I'm pretty sure we are on 12th of Jan. Your course will be completed on 26th of Jan. I don't know why the case working is doing that. For whatever reason, they don't believe something somewhere. Something is fishy. That is what they may be thinking. Uh, yeah, if your employer has an immigration lawyer who is representing them with the sponsor license, etc., usually get in touch with them and do it through some legal representatives. Yeah, sometimes these things do happen. I know case working, we do explain them a lot of things. Sometimes we have to point out the rules and everything, but engage some representative immigration lawyer and all and get it sorted. Maybe they have to write a exhaustive covering letter, get any evidence. You may get a letter from your college or something, university, stating that your course is going to be completed from on January 26th. That is one evidence. But as per the rules, you should be granted a visa because your start date of work is after your course ended. Sometimes the caseworkers Do ask for unnecessary evidence, but as per the immigration rules, you should be granted a visa. Obviously, your CAS is saying that your course is going to complete on 26th of January, and I don't know why the caseworker is asking for an evidence of course completion today, which is 12th of Jan. Doesn't make sense. Anyways, you need to engage some immigration lawyer, get it sorted, push it back on them, give whatever evidence from a letter from the university stating that your course is going to be completed on that date, 26 January. And yeah, engage an immigration lawyer. That is the only suggestion that I can make, because this is an unreasonable request from the case working when the immigration rules allow you to switch. Yeah. How long is it taking to process the DCOS for hospitality? Normal DCOS, whether it's hospitality or other than care worker and senior care worker, which are taking long and long, maybe 2 months, 3 months, or even 6 months, I've heard. All of the DCOS is usually within 2 weeks, home office is processing. So the question I have small query, please. I want to ask, I have the PTE academic will work for skilled worker visa, or I need the PT UKVI. You need the PT UKVI. So whatever that is, Pearson's test or any test, it has to have that UKVI name with that. I explained this in the previous live also. So with the UKVI, whichever test, IELTS UKVI, PT UKVI, whichever those English tests are, which has a UKVI name in that, those tests have a specific long reference number. That reference number, there is a system between Home Office and those English testing companies. So, like PTE. So, let's say the reference number is 1234. That same reference number will be mentioned on your certificate, on your when you make the booking. That reference number is there. That reference, the caseworker enters on their system and verifies the certificate and the credentials, everything, that it is a genuine one. In the past, there were a lot of issues, fraudulent certificates, all nonsense going on. Whatever different types of frauds would happen in this English testing area. So that's why TOEFL lost the license and all these others came into play. So all these other companies came in. So UKVI has sorted this out by having that reference number on the certificate, which the caseworker puts the certificate number on their system and verifies that it is a genuine thing. And that's the reason you have to give up UKVI, the test which says UKVI with that in the name. So I know that you have the PTE academic, it may not say UKVI with that, but you will have to give the one which is contains the name UKVI, UK visa and immigration. Sorry, you have to give the test again. Okay, next question. My wife's spouse visa partner year to remain here expires. She has been in the UK United General. The passport state standard, which is 5 year old. It's a long question. I'm trying to understand. I will explain it to how early can I September, 6th April, September. Last during this period with medical admin. Okay, so the question is your wife was granted under the 5 year route, the spouse visa. Yeah, whatever those BRPs are, all mentioned. My wife got a first BRP uh, in my wife. So your wife's BRP expires on 22nd April 2024. Spouse visa BRP. She has been in UK since 19 Jan 2019. So 19, 20, 21, 20, 20, 24. Okay. And the BRP was dated from 20th December 2018 with the status leave to enter. Okay. December. So December, January, February, March. Yeah. And then, okay. However, how early can my wife apply? So you can count it from the first BRP that was issued under the 5 year route to settlement. So I think from what I read, the first BRP was dated from 20th of December 2018. That is the point where you start counting. I'm assuming that was the standard 5 year route, and that was the first BRP that was starting on 20th of December 2018. You can start counting 5 years from then, and then from 28, 18, 19, 20, 21, 22, 23. So I think she's already completed 5 years, so she can apply now. from whatever dates I have in front of me. And for the excess absences of more than 6 months on the spouse visa, yes, you have said that you have all the evidences about the medical reasons. You should put all of that. Mostly, whatever applications we have done with all these excess absences, we have always got it, we've explained it. So I cannot advise you if you are doing the application. I'm not sure how good that would be. But if you engage any lawyers, that would be much better. Speak to an immigration lawyer and maybe do it through them. So that's what I can advise. There is a good chance of success. It's not that she won't be eligible for ILR just because she has those absences. But yes, you may have to put all those evidences. Preferably speak to an immigration lawyer and get a proper advice on this matter. So, settlement scheme. Hello, thank you for your video. Do you know when the pre-settlement scheme gets extended, 1 or 2 months expiration? Yeah, the pre-settlement scheme extension. So what you're referring to is this is the question under the EU settlement scheme, where the government has promised that anyone whose pre-settlement leave is expiring. So I think they started from the end of September last year. That's how I know we started getting a lot of emails. They will be automatically extended for further 2 years. That's a pre-settlement visa leave, whatever you call it, permission, will be extended for a further period of 2 years. So from September onwards, we did start getting emails for clients. I know clients have also got it. Usually it happens in the last month. I don't think they gave it more earlier than that, but it should happen by default. That's what government has promised. But will all pre-settlements get it? I'm not sure on what basis you have got the pre-settlement. So if it's a straightforward pre-settlement, you are a EU national, you have come to the UK and you have been living in the UK before the end of the transition period. That was the reason why your pre-settlement was given. It should be extended. But if you are a family member or something, spouse, partner, then we are not very sure whether they will be extending it automatically. Maybe speak to an immigration lawyer, get your facts analyzed, and then they can advise you properly on that. Yeah, if you're a European national, it happens by default. I've seen that. I have seen many of them, but it happens usually in the last month or so, and everyone is getting it. Whoever is eligible, that's what I've seen. Live advice. Okay, how to apply for undefined costs? Will you please tell me? So the question is how to apply for undefined costs. Will you please tell me? So if you are the applicant trying to apply, you cannot apply for a undefined cost. The employer has to apply. The person, the authorizing officer, or the level 1 user who has the level 1 access to the sponsor management system of the employer, only they can apply. Undefined costs usually is applied along with the license. If it's a new license, whenever we make an application and we know already, let's say you are going to hire this 1 or 2 people, we make the request of undefined costs. Okay. Hello, Baljit. Yeah, you can ask your question. So I'm explaining the undefined costs, how to apply. So the employer can go into the sponsor management system. I don't have the system in front of you, but definitely you can see the sponsor SMS. There is SMS guidance and all of that. You may have to follow that or engage an immigration lawyer, get it sorted, and ask them to do it on your behalf. Get a legal representative and ask them to do it. Or if you want, you can Google search for SMS guidances, SMS guide, I think that's what they call sponsor management system, and then follow the steps and read all the guide and do the steps yourself. So you have to go into the sponsor management system and there are different tabs. You have to select the apply for costs. Yeah, you may have to apply for change of circumstances. Yeah, usually speak to an immigration lawyer how to apply. It's very difficult. The small system is not in front of me. Yeah, so we just remember it when we go into the system. So it can be applied. The only thing I can say is whoever has access, level 1 access to that sponsor management system can log in and they can apply on behalf of the company, on behalf of the sponsor for undefined cost certificate of sponsorship. Okay. So Baljit, you wanted to ask about charity visa. Yeah, you can ask your question. I will try to see if I can answer. Another question in the comments on the channel. Sir, I got terminated from the university and my CAS end date is 23rd of September 2023. Doesn't matter. I was a student dependent. Now my wife is getting tier 2 skilled worker visa. Am I eligible for tier 2 dependent? You cannot switch. So the question is, the main applicant was a student and his wife was a dependent on him. So student and student dependent. The student's studies were terminated by the university, whatever may be the reasons. And now the wife is the dependent on student. The wife is switching to a skilled worker visa. The question is, can the student who was terminated become her dependent now? No, you cannot switch from inside the UK. You will have to go outside the UK to your home country, make an entry clearance application. You cannot switch from inside the UK. Okay. So if I spend 8 years on continuing student year for next question is, if I spend 8 years in university, including GCSE, A level, undergraduate, postgraduate, then a graduate visa for 2 years will have eligible for ILR. So the question is about what visas are allowed under the 10-year long residence. So visitor visas are not allowed. There are the changes that came into play. Temporary visas are not allowed. So you're saying GCSE, you had a child student visa, A levels, maybe child student, undergraduate student visa, postgraduate student visa, graduate route. Yes, for 2 years, will I be eligible for ILR? Yes, you can count all these types of visas towards the 10-year long residence indefinite leave to remain. So your visas would be a child student visa, then again a student visa, and then a graduate route visa. So all these visas are allowed under the 10-year long residence as of today. Those are the rules as of today. Doing advertisement outdoor for people and companies. Okay, Baljit, I read your statements. Yeah, I don't know. You ask your specific question, what you want to ask, please. Okay, next question from Priya. I am on a dependent skilled worker visa, currently working in the UK. The main applicant is taking his transfer back to India. In this case, can the employer cancel main applicant's visa? Main applicant's visa, just as it is until the expiry date, or just what happens to the main applicant visa? Will my visa also get cancelled if some cancels? Will I be given grace period? Okay, several questions in the same question, but yeah. So I'll try to answer as much as I can. So the applicant, she is on a so Priya, you are on a dependent of a skilled worker visa. The skilled worker visa is going back to India, which means their employment in the UK will be stopped, terminated, ended. Can the, in this case, your first question is, can the employer cancel main applicant's visa or just leave it as until expiry date? No, the employer has to cancel it. They have to go into the sponsor management system. If they are no longer working in the UK for the job that they have given the sponsor, it's a major compliance breach. If they have an audit, they may lose the license. They may also be downgraded to B, or they may even lose the license. So the employer has to report to Home Office within 10 days of the last date of employment. So if let's say the last date of employment inside the UK is 31st of Jan 2024, latest by 10th of February, they should be reporting through the sponsor management system and cancelling the costs, which means cancelling the permission also, skilled worker permission. There is no option. They cannot just keep that visa open. Next question. What happens to main applicant's visa? The main applicant's visa would ideally be cancelled by Home Office once they get to it. So the reporting has to be done within 10 days by the employer. And whenever the Home Office picks up, they may pick up within a month, within 10 days, or within 6 months or a year. I don't know about that. It depends on Home Office. Sometimes they pick up early, sometimes they pick up late. I've seen within a month also terminations coming in, cancellations. Sometimes over a year also they have not come in. So main applicant's visa will be cancelled by Home Office, and the dependent's visa will also be cancelled along with that. Both will be gone together. Will my visa also get cancelled? Yes. So both the main applicant and the dependent's visas will be cancelled. Will I be given grace period by his employer? Both the main applicant and the dependent will get the 60 days normal grace period that everyone gets, that is in the immigration rules. So, for example, 31st of January is the last date of employment of the main skilled worker. Say on 8th of February, they report, Home Office employer reports through the sponsor management system. Home Office picks up on, say, whatever, 31st of March. Then from 31st of March, on that date when they issue you the notice, you will have 60 days. So that letter will say that your visa will be canceling after 60 days from the date of this letter. They'll give you a specific date. So, and both of you will have 60 days and both will be cancelled at the same time. What will happen to my working rights in the UK? So you only have work rights till that 60-day period ends. Within that, you have to switch to some other category of visa, maybe a skilled worker of your own or whatever that is. Other than that, you will not have work rights after that, after the end of the 60-day period. A skilled worker visa is sponsored by his employer and I came in as dependent. Yes, I understood the facts. So those are all my answers. Okay, I have answered all the questions on the channel. So unless there are any other questions, so Baljit Singh, you said my name is Baljit Singh, sir. I wanted to ask about charity visa. Okay, I am doing advertisement outdoor for people and companies. So I don't know what you mean. Be specific on that. I can only answer 1 minute answers which I can give within a minute or so. I cannot give you whole immigration advice on a charity visa. You should speak to an immigration lawyer. We usually charge for our advice and all. If you want, you can speak to other lawyers, anyone, and take advice on the charity visa if you want all the details of charity visa. This forum is just for straight 1 minute answers that I can try and give. Okay, and thank you very much anyone who joined, and this video will be uploaded onto our channel. Anyone who was unable to join the live can see all the replies in the through the video. Thank you very much.